We on the record?
Yes.
All right. This is the time set for the 8 a.m. initial appearance calendar. I'm going to call you in individually. You'll state your name and date of birth. I will tell you what you've been booked on and whether an attorney has been appointed to represent you. I'm also going to give you the date of your next court appearance. I will let you know whether you're eligible for a bond or not. If it's a secured bond, that means you can go through a bonding company. Phone numbers for the various bonding companies are located in the jail area. You can call any one of them. They will accept collect calls. I'm also going to tell you if I've set any release conditions, like no contact with the alleged victim or no going back to the alleged scene of the crime. You need to follow each and every condition if you want to remain released. Let me remind you, you've been ordered by a court not to have contact with a victim, and then you do so, you may be charged with an additional felony. Now, when you come in the courtroom, please be aware you're being video recorded. So do not talk about the facts of your case, as you have the right to remain silent. As you leave the courtroom, court staff's going to give you your paperwork. That's going to show you your charges, whether you've been appointed an attorney or not, where, when, what time your next court date is, whether you're eligible for a bond or not, and then it'll have a list of all your release conditions. Purpose of this hearing is to determine whether you're eligible for a bond or not. That decision is based on your past criminal history, any failures to appear, your current charges in Arizona law. It's not based on personal information, so don't go into that. And finally, the court's orders for the taking of DNA and fingerprints that were given on the first calendar of March 2025 shall apply to all matters on this calendar. Can I have Veronica Flores come on in, and then Devin Bigelow to the chair outside the courtroom? All right, state your name and date of birth.
Veronica Flores, 01/11/1989.
All right, you have three matters. We'll do them one at a time. The first one is a failure to appear bench warrant for one count of shoplifting, removal of goods, class 1 misdemeanor, one count of shoplifting, removal of goods, 2 counts of shoplifting, removal of goods, class 6 felonies. You already have a court-appointed lawyer. Your next hearing will be a status conference, March 7th at 8:30. Set a $5,000 bond on that. And then the second one is a failure to appear warrant for 2 counts of shoplifting, removal of goods, class 5 felony, one count of shoplifting, removal of goods, class 1 misdemeanor. Again, you already have a court-appointed lawyer. Your next hearing will be a status conference, March 7th at 8:30. I've set a $2,500 bond. And then lastly, you've got a Superior Court new case. This alleges one count of burglary in the 3rd degree, one count of possession of dangerous drugs. Those are both class 4 felonies. One count of possession of drug paraphernalia, class 6 felony. One count of criminal trespass in the 1st degree, class 1 misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be a status conference, March 10th at 8:30. Now, I'm also going to set an evidentiary hearing for March 11th at 1:30. Arizona has a criminal rule of procedure, 4.2A7A, which states that if you're out on release on a felony and you allegedly commit another felony, you can't bond out. You're non-bondable. But you and your attorney, you get to challenge that. And that's going to be at that hearing that I've set for March 11th. Get your paperwork from the court staff. Devin, come on in. And then Dean Colwell to the chair outside the courtroom. Sir, state your name and date of birth.
Devin Bigelow and 3388.
Okay, you have a Navajo County Superior Court. This is a probation warrant on your probation that you're on for a felony.
Yeah.
Now, I can't appoint you an attorney here, but if you're eligible, they'll have to appoint you an attorney in Navajo County. Your next hearing will be in arraignment March 12th at 8:30. And pursuant to Arizona Criminal Rule of Procedure 7.2C, you'll be held non-bailable, and they'll have to come get you.
So what's that mean?
That means that Navajo County will come get you sometime between now and the 12th.
Okay.
Okay, get your paperwork. Dean Colwell, come on in. Richard Triplett, to the chair outside the courtroom. Sir, state your name and date of birth.
Dean Colwell, 10489.
All right, you have 4 matters. The first one is a Superior Court new case alleging one kind of possession of narcotic drug class 4 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference March 10th at 8:30. I've set a $2,500 bond. Now, the other 3 are all probation violations. You're on probation for 1 class 4 felony and 2 class 6 felonies. Probation is alleging you violated term 3 and 5 on each of these. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition, March 11th at 8:30. Pursuant to Arizona Criminal Rule of Procedure 7.2C, you'll be held non-bailable on all 3 of those probation violations. Get your paperwork from the court staff. Richard Triplett, come on in. Over here. And then William Auget to the chair outside the courtroom. Sir, state your name and date of birth.
Richard Lewis, Triplett 9361, ma'am.
All right, you have 2
Your Honor,
matters.
I'm
The first, I'll try and go as fast as I can,
No,
all right?
no, take your time, please.
You've got a Superior Court new case alleging 2 counts of aggravated assault with a deadly weapon or dangerous instrument. Class 3
two
felonies.
counts? 2 counts, ma'am?
2 counts, 1 for each person. I've appointed a lawyer to represent you. Your next hearing is going to be a status conference March 10th at 8:30.
Yes, ma'am.
I've set a $70,000 bond on that. Now you've got a probation violation, too. You're on probation for a class 4 felony. Probation is now alleging you violated your probation by getting the new charge, a term 1. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition, March 11th at 8:30. And pursuant to Arizona Criminal Rule of Procedure 7.2C, you're going to be held non-bailable.
Of course not.
Get your paperwork from the court staff.
Oh, my God.
Ring William.
Oh, my God. Oh, my God. Oh, my God.
And then Bill Colson to the chair outside the courtroom. Sir, state your name and date of birth.
Ring of God, 02/25/2004.
Okay, you've got a Superior Court new case alleging 1 kind of aggravated assault with a deadly weapon or dangerous instrument, class 3 felony, 1 kind of disorderly conduct with a weapon, class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, March 10th at 8:30. I've set a $20,000 bond. No returning to the alleged scene of the crime and no contact with the alleged victim. Get your paperwork from the court staff. Bill Colson, come on in. Keith Lee to the chair outside the courtroom. Sir, state your name and date of birth.
Owen Colbs, August 27, 1969.
You have a grand jury warrant, which means the grand jurors met, they heard testimony, they found probable cause on 1 count making a terrorist threat, class 3 felony, one count of criminal damage, class 5 felony, one count of criminal damage, class 2 misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, March 12th at 8:30. I've set a $15,000 bond. Get your paperwork from the court staff. Kit, Lee.
Oh, it's on the paper? Never mind.
And then Wyman Batiste to the chair outside the courtroom. Sir, state your name and date of birth.
My name is Keith Lee, and date of birth is November 9th, 1999.
You have a Superior Court new case alleging one count of trafficking and stolen property, class 2 felony. One count of shoplifting, removal of goods, class 5 felony. I did not have enough information to determine whether you're indigent or not. So you can do one of two things. You can either hire your own attorney, or when you go to court the next time, there's that form that I guess they tried to go through with you, and you've got to fill that form out to see if you qualify for a court-appointed lawyer. Your next hearing is going to be a status conference March 10th at 8:30. Set a $7,500 bond. No returning to the alleged scene of the crime. No contact with any victim. Get your paperwork from the court staff. Wyman Batiste. Come on in. Timothy Williams to the chair outside the courtroom. Sir, state your name and date of birth.
Wyman Batiste.
Date of birth?
09/17/89.
You have a Superior Court new case alleging one count of aggravated DUI while license suspended or revoked, class 4 felony. One count of aggravated DUI with a passenger under the age of 15, class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference March 10th at 8:30. Set a $5,000 bond. Absolutely no possessing of any drugs without a valid prescription, and no driving a motor vehicle with anyone under the age of 18. Get your paperwork from the court staff. Timothy Williams, come on in. Tyler Washington to the chair outside the courtroom. Sir, state your name and date of birth.
Timothy Henley Williams, July 3rd, 1987.
All right, you have a Superior Court new case alleging 2 counts of possession of narcotic drug. I only found probable cause on 1. There was another substance that they didn't test. If they test it, they will file the charge. But I only found probable cause on 1. And then 1 count of possession of drug paraphernalia, class 6 felony. 1 count of shoplifting, removal of goods, class 1 misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be a status conference March 10th at 8:30. Set a $3,600 bond. No returning to the alleged scene of the crime.
Miss, I would like to challenge the jurisdiction of this court to hear this case because it falls under the original jurisdiction of Article 3.
Okay, wait. I can't hear you. Speak up louder.
I would like to challenge the jurisdiction of this court to hear this case because it falls under the jurisdiction of Article 3, Section 2, Clause 2 of the U.S. Constitution. By the U.S. Constitution, I'm guaranteed due process, which means the process that the U.S. Constitution provides and the power that it vests to make, enforce, and interpret the law. Which the U.S. Constitution doesn't give this court where does the U.S. Constitution give this court the authority to prosecute me to convict me of a crime that is by definition slavery? Because a conviction, just like due process, also has to come from the process the U.S. Constitution provides and the power.
Okay, sir, I would urge you to talk with your lawyer about that. But the state of Arizona and Maricopa County does have jurisdiction over all felonies that are committed in the state of Arizona.
And Article 3, Section 2, Clause 2 says all cases in which
I've taken into consideration in this, that you're having due process here, that you have 11 prior failures to appear in court and 5 felony convictions previously. So therefore, you will be held on a $3,600 bond. Get your paperwork from the court staff. Tyler Washington, come on in. And John Green to the chair outside the courtroom. Sir, state your name and date of birth.
Washington, April 27, 2003.
All right, you have three matters. The first one is a Superior Court new case alleging 3 counts of organized retail theft, Class 4 felonies. I've appointed a lawyer to represent you. Your next hearing will be a status conference, March 10th at 8:30. I've set a $2,500 bond. Now, the next two are both probation violations. You're on probation for 2 Class 6 felonies. Probation now is alleging you violated your probation because you got new charges. It's called a Term 1 violation. I've appointed a lawyer on both of those to represent you. Your next hearing will be an arraignment, possible disposition, March 11th at 8:30. Set a $900 bond on each of these. If you post these 3 bonds, you must contact your probation officer within 72 hours. Get your paperwork from the court staff. John Green, come on in. William Spires to the chair outside the courtroom. Sir, state your name and date of birth.
John Marshall Green, Jr.
Date of birth.
5/28/84.
You've got a Superior Court new case alleging 1 count of possession of dangerous drugs, Class 4 felony, 1 count of possession of drug paraphernalia, Class 6 felony, 1 count of shoplifting, Class 1 misdemeanor. I've appointed a lawyer to represent you. Your next hearing will be a status conference, March 10th at 8:30. Set a $2,500 bond. No returning to the alleged scene of the crime. Understood?
Yes, ma'am.
Get your paperwork from the court staff. William Spires, come on in. Eric Harrison to the chair outside the courtroom. Sir, state your name and date of birth.
William Spires, 32571.
You've got a probation violation warrant for your probation that you're on for a Class 4 felony. Probation is alleging you violated term 1, 2, 3, 4, 5, 7, and 15. I've appointed a lawyer to represent you. Your next hearing will be an arraignment, possible disposition, March 11th at 8:30. Set a $1,500 bond. If you post that, you must contact your probation officer within 72 hours. Get your paperwork from the court staff.
Can I say something? I tried to get into a rehab, and they wouldn't accept me because I don't do fentanyl. I continued to try, and I told him about it, and he just didn't care.
Well,
I need the judge to send me to or put me in a rehab.
Okay, that's good to hear. You should talk with your attorney about that. You have a lot of, obviously there's a lot of violations that they're talking about here.
Yeah, I don't know how.
Yeah, but talk to your lawyer about that, okay?
All right.
All right, good luck to you. Eric Harrison, come on in. Jason Sprague to the chair outside the courtroom. Sir, state your name and date of birth.
Eric Harrison, 2788.
Got a Superior Court new case alleging 1 count of possession of narcotic drug, Class 4 felony, 1 count of possession of drug paraphernalia, Class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, March 19th at 8:30. I'm going to release you pretrial services. You're going to have the drug test with them. Don't miss court. Did you see all those people that failed to appear and then they get a bond and they get all upset? Go to court, all right?
Yes, ma'am.
All right, get your paperwork from the court staff. Jason Sprague, come on in. Jamar Graham to the chair outside the courtroom. Sir, state your name and date of birth.
Jason Sprague, 42378.
Okay, you've got a Superior Court new case alleging 1 count of possession of narcotic drug, Class 4 felony, 1 count of possession of drug paraphernalia, Class 6 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference, March 19th at 8:30. I'm going to release you to pretrial services. You're going to have the drug test and be monitored, okay? All right, get your paperwork from the court staff. Jamar Graham? State your name and date of birth.
Jamar Christopher Graham, 09/18/2002.
All right, you have a Superior Court new case alleging one count of possession for sale of dangerous drugs, Class 2 felony, one count of possession for sale of marijuana, Class 4 felony. I've appointed a lawyer to represent you. Your next hearing will be a status conference March 19th at 8:30. Normally, I'm going to tell you on these charges, you'd have a really high bond, but you don't have much of a record. I will tell you the county attorneys requested $2,500. Let me suggest to you, because you have a conviction, but only one, and it was 3 years ago, that you show up for court on the 19th, because you've got some serious charges here, but I'm giving you an opportunity to be released and show the judge and maybe the prosecutors that you will continue to show up for court and that you don't need a bond. Do you understand that?
Yes, ma'am.
All right. Good luck to you. Get your paperwork.
Thank you.
And then also on this calendar, I read, received, and considered a victim statement on number 30. And then we have a number of house calls. Why is Ivan Herrera a house call?
Yes, he's and safe cell. He's a suicide watch.
Safe cell for what?
Safe cell 8 and suicide watch.
Ivan Herrera, date of birth 3/10 of 1989. He's here on one count of burglary in the 3rd degree, Class 4 felony. I've appointed a lawyer to represent him. His next hearing will be a status conference, March 10th at 8:30. Set a $3,600 bond. Why is Jonathan Rude a house call?
House call. He is a safe cell 7. He's on Northbound, dangerous to cell.
Jonathan Rude, date of birth 6/14 of 2001. He has one count of aggravated assault on a first responder, Class 5 felony. I've appointed a lawyer to represent him. I did change it. It was initially a Class 6 felony, and I corrected that to a Class 5. His next hearing will be a status conference, March 10th at 8:30. Set a $2,500 bond. Then Amy Pate, why is she a house call?
She's on holding cell 8. She's distracted, 9/18.
Amy Pate, date of birth 9/25 of 85. She has a failure to appear warrant for one count of possession of narcotic drug, Class 4 felony, one count of criminal trespass in the 3rd degree, Class 3 misdemeanor. She already has a court-appointed lawyer. Her next hearing will be a status conference, March 10th at 8:30. I've set a $500 cash bond. Then David Watson, why is he a house call?
He's on holding cell 7, Your Honor, and he's refusing court testimony.
David Watson, date of birth 3/28 of 1990, has a Superior Court arrest warrant alleging one count of possession of narcotic drug, Class 4 felony, one count of possession of drug paraphernalia, Class 6 felony. I've appointed a lawyer to represent him. His next hearing will be a status conference, March 10th at 8:30. Set a $250 bond. And then lastly, Adrian Lopez. Why is he or she?
Adrian Lopez in holding cell 4, also refusing court testimony.
Okay, Adrian Lopez, date of birth 6/20 of 89, has 3 matters. They're all probation violations. He's on probation for 2 Class 4 and 1 Class 6 felony. Probation is alleging he's violated term 3 and 5. I've appointed a lawyer to represent him. His next hearing will be an arraignment, possible disposition, March 11th at 8:30, pursuant to Arizona Criminal Rule of Procedure 7.2C. He'll be held non-bailable on each of these.
about what you were arrested for?
Yeah.
Okay, then, do you remember that you have the right to remain silent in this criminal case? I need a yes or no.
Yes.
Do you understand that you have the right to a lawyer? I'm appointing one for you, but you haven't met them yet. Do you understand all of those things?
Yes.
And do you understand that you could face very significant prison time in this case if you are convicted? Yes or no?
Yes.
All right. So for most people, I will also end up advising them that if you're going to talk about what you've been accused of, it could be used against you in ways you cannot imagine today. This hearing's being audio and video recorded. Do you understand? This could be played at your trial. Do you understand that? Yes or no?
Yes.
All right. And so I'm not encouraging you to talk about what you've been accused of. I'm not compelling you. I would allow you if you insist on doing it. That being said, people who make incriminating statements in an attempt to get a better bond, such that they set themselves up for potential conviction on a 10-year presumptive, are doing bad math. That is my considered legal opinion, is that it is not in anyone's best interest to potentially incriminate themselves in a case like this to try to get a better bond, especially when they have a DOC hold. So, Mr. Purview, that being said, you appear to understand your rights. I've given you the best caution that I know how to give you. What did you want to say?
I just wanted to say that the two people that were in the car with me are not responsible for anything in any way, and I don't know why they're being charged. So that's...
All right, none of that is relevant to what you're telling me. The probable cause finding is absolutely also appropriate with respect to each of them. Probable cause is not conviction. So, that being said, Mr. Purview, talk to your lawyer about all of that. They can talk to their lawyers. They also have lawyers. So we're going to get you a copy of your paperwork, and you can step out to your left. All right, Mr. Lucetto. Hello, sir. Can I have your full name and date of birth, please?
Luis Lucero, 1013-2002.
All right, thank you. You're here on a new case. You got arrested for aggravated assault in violation of a protection order that is a Class 6 felony, disorderly conduct, a Class 1 misdemeanor, assault, a Class 1 misdemeanor, and interfering with judicial proceedings by disobeying a court order. That's a Class 1 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer for you in this case. Your next court date is a status conference March 10th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing March 13th at 8:30 in the same court. Your bond is $5,000. It is secured. That means you can use a bail bond. If you post it, you will be on an ankle monitor under the supervision of pretrial services. That is an attempt to keep you honest about complying with these court orders and your release condition. You may not go to nor live at the scene of the alleged crimes. You may do a civil standby one time to collect belongings, and then you must provide proof of a new residence to pretrial services within 24 hours. Absolutely no contact with the alleged victim. You may not respond to contact from the alleged victim. If you have children in common with that person, and that means that you may not be able to see your children without violating this order, then you will not see your children. Violation of this order in any way that could be probable cause for harassment will result in you being held without bail if you get an initial appearance on that type of arrest. Harassment in violation of this order can be a no bond felony hold. Harassment in violation of an order of protection is a misdemeanor. Assault in violation of an order of protection is a felony. So, Mr. Lucero, talk to your lawyer about this, but violating these no contact orders would be what I would like to describe as extremely bad math. If you do it, don't do it from jail. Don't do it if you're out of jail. No weapons, no drugs, no alcohol. You must obey with the terms of any and every order of protection that may have been served on you. So we're going to get you a copy of your paperwork. If you'll step out to your left. Thank you. Ms. Elgin, Kate Elgin, and then Danny Barraza, will you please go to the chair? Hello, ma'am. Can I have your full name and your date of birth, please?
Yeah, Kate Ely Elgin, and June 28, 1990.
All right, thank you. You are here on 4 matters. 1 is a new case. 3 are probation holds. In the new case, you were arrested for organized retail theft, or also, I think in your case, a PC was organized retail theft, intent to resell. Yes. So that is a Class 4 felony. Shoplifting, a Class 1 misdemeanor, and false reporting to law enforcement, a Class 1 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer for you in this case, and in each of your probation cases. You are on probation in 3 different felony cases. Petitions to revoke your probation will be filed in all 3 cases. So you'll have a lawyer for everything. In your new case, your next court date is Monday, March 10th at 8:30 for a status conference. Preliminary hearing March 13th at 8:30. The court address is on your paperwork. In your probation cases, you will go to court March 11th at 8:30 in the morning. That's 1 week from today for a revocation, arraignment, and possible disposition hearing. And in each of your 3 probation cases, you have a $2,500 secured appearance bond for $7,500 total. In your new case, the court sets a $50 placeholder bond to make you eligible for credit for time in custody in that case, should you end up convicted. Your total bond is $7,550. It is secured. Everything's on your paperwork. If you bond out, call your PO within 72 hours. She's got that for you. Mr. Barasa? And then Kimberly DeToro, will you go to the chair, please? All right, how about Kimberly DeToro, if Mr. Barasa is waking up? Yeah, go ahead and come in, ma'am. Mr. Barasa, go sit just at the chair inside the door. Go ahead. No, it's fine. Whatever. He just moving very, very slowly. All right, Mr. Barasa, right here at the podium.
Sorry about that.
Oh, that's all right.
Neuropathy.
You were supposed to have been in the chair. That's all. Can I have your full name and your date of birth, please?
Danny Barraza, 1981.
Okay, thanks. You're on 1 new case and 3 probation warrants. In your new case, you were arrested for false reporting to law enforcement. It's a Class 1 misdemeanor, and there is probable cause for it. I am appointing a lawyer for you just to help you with the bond issue only. You'll have an arraignment hearing March 7th at 8:30 in the morning on that charge in the West Mesa Justice Court. That is this Friday. That is 3 days from now. You are also here on 3 probation violation warrants that went out for you on February 27th. You are on probation for 3 felonies, and there were already petitions to revoke your probation filed in all 3 cases. They allege that you violated terms 3 and 5. You'll get copies of those from your lawyer, and you will have a lawyer appointed for all 3 of these probations. Your court date in the downtown probation court will be 1 week from today, which is March 11th at 8:30 in the morning. The court address is on your paperwork. That's a revocation arraignment and possible disposition hearing. In each of your 3 probation cases, your bond is $2,500 secured. In the new case, a false reporting case, your bond is $500 secured. That is $8,000 total. If you bond out, comply with all of your written conditions, call your PO within 72 hours. The number is on your paperwork. If you step to your left, she'll give you a copy of that.
Thank you very much.
Mr. Toro, after that, Sheila Brody, will you please go to the chair? Hello, ma'am. May I have your full name and your date of birth, please?
Kimberly DeToro, 9/9/1982.
All right, thanks. You're here on 2 warrants from the Pinal County Superior Court. In number 3 on the calendar, you've been charged with aggravated assault on a law enforcement officer involving any injury, that is a Class 4 felony, disorderly conduct, a Class 1 misdemeanor, and criminal damage, a Class 2 misdemeanor. In the other case, number 4 on the calendar, you've been charged with possessing dangerous and narcotic drugs, those are Class 4 felonies, and drug paraphernalia possession, a Class 6 felony. I will let them know they should appoint a lawyer for you when you get there, if they haven't already. Your court date in Pinal County is set for this Friday, March 7th at 8:30 in the morning. That is 3 days from now. I am affirming the bond set by the Pinal judge. Wait a minute, let me look at 4. I think I have a typo in 4. I do. I have to reprint the one that's the drug case, because it's $500 secured appearance bond in each case, so that is $1,000 total. So we do need to reprint one of those because it had a typo in it. And so if you post it, you have to be in Pinal County on Friday, or you will lose that bond money. They're going to issue another warrant for your arrest with a much higher bond. If you don't bond out, the Pinal County sheriffs are going to come and get you from Maricopa. So give us a chance to reprint that one, and we will send it out to you. It's $500 per case, so the one that says 50, we need to reprint. Okay, thanks. All right, Sheila Brody, will you please go to the podium, please? And then Austin Lee, will you go to the chair, please? Hello, ma'am, can I have your full name and date of birth?
Sheila Brody, 7/30/97.
97? Okay, thanks. You're here on a probation warrant. You're on probation for a Class 6 felony, and there was a petition to revoke your probation filed on February 5th of this year. It alleges that you violated terms 3 and 5 of your probation. I'm appointing a lawyer for you. You will see the probation judge 1 week from today, which is March 11th at 8:30 in the morning for a revocation arraignment and possible disposition hearing, I am affirming the $250 secured appearance bond that was set by the judge who issued the warrant. So it's $250. If you bond out, comply with all of your release conditions, and call your PO within 72 hours. If you step to your left, you get a copy of your paperwork. Thank you. All right, Mr. Lee, and then Jacob Franklin, will you go to the chair, please? Yep. May I have your full name and your date of birth, please?
Austin Joseph Lee, 22596.
All right, thank you. You're here on a new case. You're arrested for aggravated driving under the influence of alcohol or drugs with a passenger under the age of 15 in the vehicle. That is a Class 6 felony. Endangerment, a Class 6 felony. Driving under the influence of alcohol or drugs while impaired to the slightest degree. Driving with blood alcohol of 0.08 or more. An extreme, actually this is what we call super extreme DUI, which is blood alcohol of 0.20 or more. All of those last three are Class 1 misdemeanors. The penalties differ considerably depending on which one a person is convicted of. So you can talk to your lawyer more about that. I am appointing a lawyer for you. The next court date is a status conference, March 19th. So that is 2 weeks from tomorrow at 8:30 in the morning in the downtown Superior Court. With a preliminary hearing that Friday, March 21st at 8:30. That is on your paperwork. And I'm going to release you to pretrial services with alcohol and drug testing. You will be alcohol and drug free while the case is pending. You will test to prove it. You will not drive with anyone under the age of 18 in the vehicle, whether they are your child or anyone else's child. You do not drive with anyone under the age of 18. And I will permit you to have contact. Let me ask you this. Is the alleged victim under 15, is that person your child?
No, it's my best friend's son.
Okay, all right. This will be easy then. Actually, I assumed that it was, so I'm actually just gonna, I'm gonna do no victim contact. The other one, is the other one your child, but over 15? No. Was there anyone else under the age of 18?
No.
So, no, I don't want to force you to answer a question. I'm just trying to figure out, I want to order no contact with the alleged victim. Endangerment is a victim crime. There is an alleged victim. And for purposes of this order, what I mean is the under 15-year-old plus anyone else under the age of 18 in the car is who I want to order you not to have contact with. So let me ask you this. Were there any of your own children under the age of 18 in the car? Okay. Then I do want to reprint his officers just so we can be clear. Okay, so this will be easier for you to comply with. Do not have contact with that kid. That's the alleged victim when you see it because it's of the endangerment count. It just gets more complicated when it's a person's own child. Not that I haven't ordered people to have no contact with their own child if the court believes that they are likely to drive with that child in the car and very likely kill them. Small children do not survive car accidents. But in any event, no alcohol, no drugs, no driving with anyone under the age of 18. You're going to get an envelope that gives you instructions to call pretrial after you get out. Do not lose that envelope or you will screw this up and the court will be notified and problems will ensue. Your lawyer will tell you when you finally meet them, positive tests are, can hurt you, but not testing hurts you more. Negative tests can help you. So the extent that you go in and you're testing negative, your lawyer can use that to help you. So I'm telling you that to try to motivate you to follow these orders, stay clean, do not miss your court dates. All right, if you step to your left, she'll give you a copy of that.
Thank you.
Thank you. Mr. Franklin, and then Francisca Oviedo Torres. Will you please go to the chair? Hello, sir. May I have your full name and your date of birth, please?
Jacob Franklin, 10/02/2004.
All right, thank you. You were arrested for aggravated driving under the influence of alcohol or drugs with a passenger under the age of 15 in the car. That is a Class 6 felony. And underage person driving after any drinking at all, which is a Class 2 misdemeanor. There is probable cause for both of those, and I am appointing a lawyer for you. Your next court date is in 2 weeks, which is a status conference, March 19th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing March 21st at 8:30 in the same court. That will be on your paperwork. And like the previous defendant, because you don't appear to have a history of this, I'm going to release you to pretrial services with alcohol and drug testing. And in your case, very surprisingly, they did not book you for endangerment. There's absolutely probable cause for that because whether somebody is ingesting alcohol or not, well, going over 100 miles on the freeway at all is endangerment of a child. It's endangerment of everybody that you're with or who you pass on the freeway. Also, as I mentioned before, tiny infants do not ever survive car accidents. They don't survive 20-mile-an-hour car accidents. They become blood smears on the pavement at 100 miles an hour. Just ask anybody who has had to respond to that type of crime scene. And they will tell you that they have PTSD from chunks of small children that they have had to pick up out of the roadway. Babies don't stay in car seats. They don't survive it at all. They cannot take the force. Even if the car seat holds them in, the car seat will crush their chest and stop their heart, sometimes decapitate them. So I would have found probable cause for endangerment. I don't know if that's your child. I'm going to assume that you have a basis to have contact with that child, but I'll just ask you, do you have any children of your own?
Yes.
All right. Are they under the age? Well, I assume they're, yeah. Mathematically speaking, they have to be under the age of 15. So what I'm going to permit is you may have contact with that alleged victim if it's your child. Is that your child?
Yes.
All right. So long as you do not drive with that victim or anyone under the age of 18 in the car. So you're done driving the baby while the case is pending. Other people must drive the baby. You will drug and alcohol test for us to prove that you're not using. And if something happens to your driver's license, then you can't drive at all. But right now, because you don't appear to have a history of DUI, I'm not prohibiting you from driving. I'm just categorically prohibiting you from driving with anyone under the age of 18 in the car because they cannot protect themselves from the potentially fatal decisions of adults. And so just respect that. Comply, call pretrial when you get out, start complying. And as I told the previous defendant, to the extent that you come in with clean tests, your lawyer can definitely use that to help you. So everything's on your paperwork. If you step out to your left.
Thank you, Your Honor.
Thank you. Ms. Oviedo Torres, and then Araya Fletcher. We go to the judge. Hi, ma'am. Can I have your full name and your date of birth, please?
Francisco Villa Torres, 11/27/1987.
All right, thank you. You're on a new case and a warrant for an older case. In the new case, you have been arrested for aggravated driving under the influence of alcohol or drugs, with a license suspended or revoked. That is a Class 4 felony. There is probable cause for it, and I am appointing a lawyer for you. I'm also appointing a lawyer for you in your older case, because back in 2020, December 19th of 2020, you were also accused of those two crimes, aggravated DUI, same crime. What they do is they allege a violation of the statute in two different ways. So both of those ways are Class 4 felonies, and it looks like this warrant went out in August of 2022. So you'll have the same lawyer for both cases. You have the same next court dates. The first one is a status conference, March 19th at 8:30 in the morning in the downtown Superior Court. The second is a preliminary hearing, March 21st at 8:30 in the same court. And in each of these cases, I'm going to release you to pretrial services with alcohol testing and monitoring. If your history is what it looks like, you are almost unequivocally an alcoholic and you do not have the right to drive. So you will not drink while the case is pending. You will not drive. It can be dangerous to stop alcohol cold turkey. That being said, if you fail to test, that will be held against you. If your numbers are declining, your lawyer can use that in your favor, or if you're testing clean, just like I told the last people. You are not to drive at any time. I put it two places in your order because you lost that right years ago. And so you will not drive. If you would hurt anybody, I would just be giving you a high bond and you wouldn't get a lecture. People who commit this type of offense repeatedly and who are alcoholics don't stop until they get put in prison or they kill themselves or somebody else. Sadly, it's usually somebody else. Right now, as currently alleged, you face mandatory prison in both cases. You may not know that. Mandatory prison, no matter what comes out. On a first-time offense, it's 4 months in the state women's penitentiary. Did you know that? Now you do. You will suit up in a jumpsuit at the Perryville State Women's Prison for a minimum of 4 months. No judge can give you less. You cannot get probation until you've done 4 months in prison. On a second or subsequent, it's prison mandatory. So at this point, the county attorney has two chances to put you in an orange jumpsuit in prison. If you do it while the case is pending, they are going to make you a mandatory prison offer. And with 3 cases, it's probably going to be 4.5 years. That is their offer, because you could face 10 if you lose all 3 cases at trial. I'm trying to do math for you because I hope it will make you a lot more likely to comply with my order not to drive. Because, as I said, I do the cases for people who murder other people with this kind of behavior. And so when I see it going back to 2020, I see that kind of BAC, that sends a very strong message about what the likelihood is that you will hurt or kill someone if you get behind the wheel. You lack the right to do that. So I hope that your own self-interest will make you comply with my orders. That's the best I can do. Again, if you had been in any collision, in this case, or hurt anyone, I wouldn't be bothering to lecture you. I would just give you a high bond and see if that will keep you off the street. You step to your left, you get a copy of your paperwork. Ms. Fletcher? And then Laurentina Heidi, will you please go to the chair? Fellow ma'am, may I have your full name and your date of birth, please?
Araya Fletcher, 02/21/98.
Okay, thanks. You're here on a new case. You got arrested for aggravated DUI, both with a suspended license, which is a class 4 felony, the one with the mandatory prison. Did you just hear me tell her?
Yes, ma'am. I was listening.
And then aggravated DUI with a passenger under the age of 15 in the car. That's a class 6 felony. There is probable cause for both of those, and I am appointing a lawyer for you. Your next court date is a status conference, March 19th, which is in 2 weeks, 8:30 in the morning, downtown Superior Court. Preliminary hearing March 21st at 8:30 in the same court. I'm going to release you to pretrial services with alcohol testing as well. It's also very likely that you can, they're probably going to wait for blood results as well.
Mm-hmm.
That being said, they don't have to. You don't have an enormous history of this, and it does not appear that the license suspension was for DUI. It's a different calculus if it is. Yours appears not to have been, which also means the county attorney could make you a better deal, or they may not pursue that charge. That's up to the county attorney, not me. So talk to your lawyer about that. That's why you get a lawyer. This is factoring into why I'm not giving you a bond, why I'm going to let you go to pretrial services with alcohol testing. You are ordered not to drive any motor vehicle at any time. You don't currently have the right, and based on this, it looks like what they're alleging was, again, an infant. Honestly, people have no concept of the physics. It tears people's body parts off. Infants, I can't say enough about how unspeakably dangerous it is to infants to speed, and people think that the car seat just is a magic shield for an infant. Infants die in car seats all the time in high-speed crashes. So, you are not to drive at all. I didn't bother to check the box saying under the age of 18 because you cannot drive. No weapons, you're a prohibited possessor. No alcohol no alcohol at all. No drugs without a valid prescription. And as I told the last defendant, if you test clean, your lawyer can use that to help you. If you test dirty, okay, they will deal with that. If you don't test at all, that will be held against you. You step to your left, you get a copy of it.
I got a quick question. So, like, if I test now, of course, it's okay.
But they're going to look for numbers to decline. So
Okay.
if they tell you to test tomorrow and there's still something off gassing, the people who look at these, they have a very good idea of what it looks like when somebody is or isn't using. And so alcohol can take a few days to come out of your system. If they see a small amount, they're not likely to declare that meaningful. I'm not telling you to go out and have a sip of a beer. That being said, you might be surprised at how much they know about what they're looking at depending on what people are doing. If you show up diluted, nobody thinks that's accidental. It's almost impossible to dilute a urine test accidentally. That means you were deliberately trying to dilute something and everybody holds it against you.
Yes,
So
ma'am.
don't do that either. But anyway,
Yes, ma'am. Thank you, Your Honor.
Good luck, ma'am. Ms. Heidi, and then Rosario Valle, please go to the chair. Hi, ma'am. Can I have your full name and your date of birth, please?
Laurentina Renee Heidi, December 21st, 1987.
Thanks. You're hearing a new case. You got arrested for dangerous drug possession, class 4 felony, drug paraphernalia possession, class 6 felony, and shoplifting, a class 1 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer to represent you. Your next court date is a status conference March 19th, which is in 2 weeks at 8:30 in the morning in the downtown Superior Court. And your preliminary hearing is March 21st at 8:30. So this is 2 weeks from now. And based on your criminal history, you don't have any felony priors. I'm just going to release you to pretrial services. We're not going to spend money right now having you drug test because we all assume it would be positive and you're not getting any treatment right now. And right now, there aren't safety issues implicated. So basically, it saves the taxpayers a little money. You need to go to court.
Yes, ma'am.
Comply with your conditions, which still include no drugs without a valid prescription, no weapons, do not go back to the store or have any contact with any of the witnesses there. Everything's on your paperwork. You get the envelope as well to call pretrial services. Just follow those instructions when you get out. Okay?
Okay.
All right, thanks, ma'am.
Thank you.
Mr. Rosario Valle and then Stuart Knebel, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Jerry Rosario Valle, February 13, 2004.
Okay, thanks. You're here on a new case. You got arrested for reckless driving, which is a Class 2 misdemeanor, and criminal speeding, which is a Class 3 misdemeanor. There is probable cause for those. I'm not appointing a lawyer for you, though, because I am planning to release you. You would only get a lawyer if there was a bond you could not afford. I'm going to release you on the theory that a night in jail is enough to motivate you to comply with your release conditions and come to court. So your arraignment hearing will be March 20th at 8:30 in the morning. That's a little over 2 weeks in the El Centro Justice Court, which is right downtown. Again, I'm going to release you on your own recognizance. Also, you were smart enough not to flee from the cops. You'd be surprised at the number of young men accused of speeding on fancy motorcycles. I don't know if yours is fancy. And they panic or they think they can outrun the cops. They don't, and then they end up standing before me on a felony. I take that as a lack of intelligence. So hopefully, so I'm just saying that actually factors into they're not accusing you of running. They're not accusing you of endangering other people mostly than yourself. So just comply with your release conditions. Don't miss court. By the way, I sign DUI warrants statewide. We all do. Everybody who works here, we get electronic warrants statewide. The number of people who get smashed, beat up, horribly maimed by traffic splitting is really shocking. It's shocking to me that it's legal in California or states like that. I get why, because I've been to California. It is categorically dangerous. Somebody's going to kill you if you do that. And it happens in California all the time. They just decided cost benefit, traffic's really bad. We'll let motorcyclists potentially kill themselves with this unbelievably dangerous traffic move. So that's just a little personal PSA for, I literally read, I'm going to say once a month, which I only do an eighth of what's down here. Once a month, somebody's splitting traffic. They're either the drunk who then bounces off somebody, or somebody hits them. That's not even counting the people who aren't drunk, and they change lanes, and they don't realize here comes somebody splitting traffic, and a sober person could change lanes into you, and you don't survive. They're fine. Their car's scratched. You're dead. Whereas if they're drunk, that's when I would see the warrant, or they're high. The person takes out the motorcyclist because they're drunk or high, and the motorcyclist is splitting traffic. So anyway, that's just mostly a PSA because you're young, and they don't allege any criminal history, and probably you should value your life more. If you step to your left, you get a copy of your paperwork.
Thank you.
Mr. Knebel? Full of wisdom today. All right, sir, can I have your full name and your date of birth?
Stuart Knebel, 8/28/90.
Okay, thanks. You're heard a warrant from Santan Justice Court. It's a post-conviction warrant in an extreme DUI case. You've already been convicted. This warrant issued February 10th. That's very scribbly. Could be the 20th of 2025. So just a little bit ago. Your next court date is going to be in the Santan Justice Court, which I think is in Chandler. Arraignment March 18th, which is 2 weeks from today, 9 in the morning. According to what I can see of their paperwork, this is your first post-conviction warrant in this case. And looking at it, the only note, I get very abbreviated warrants. It looks like you got to show your interlock proof. There's probably other things. Chances are people owe money. I don't know if you owe their jail time. I don't know. I'm hopeful that a night in jail is enough to get you to go and talk to them about whatever it is that you're not doing for them. But this is a first post-conviction warrant. You didn't run, lie, or fight with the cops. So I'm going to let you go to court on your own. If you do not, I will see it. That's a failure to appear. And on this type of case, probably easily a $500 bond. So go talk to them March 18th. Figure out what's missing. Get on a plan with them, okay? Everything is on your paperwork, okay? You step to your left, you get a copy of that. Interesting. Okay, so officer, I've got 2 house calls. I have Mr. Matamua Frazier and Sarah Valdez. Are they not physically present in court because they were isolated as possible risks to themselves or others?
Yes.
Okay. And so Valdez, I know why. Matamua Frazier, I'm just curious because he's kind of on the bubble. Have you talked to him recently? Does it seem like he has sobered up, or is he still?
He's straightening everybody to harm them.
Okay, and can you tell how long ago that was? Was that like third shift?
Sorry.
Was that in like a note from third shift, or it's pretty recent?
I don't know.
Okay, I'm just trying to figure out, is he safe to release now? So, all right, okay. All right,
It was Valdez assault.
She's the one who, yes, no, her, I know, right, okay, I got you, thank you. All right, so I am going to go conduct those initial appearances in-house immediately after this recording, and I'll advise Mr. Matamura Frazier, first name Wendell, whose birthday is 7/9/2003, that he got arrested for assault. The class 1 misdemeanor is going to go out of the Buckeye City Court. And I'm going to give an arraignment hearing of March 18th at 2 p.m. in the Buckeye Court. I'm not appointing a lawyer for him because it does not say that it's DV, but I'll advise him he has the right to hire one. And I'm currently planning and hoping to release him on his own recognizance. The Form 4 suggests that it was intoxication that led him to be here today, and the Form 4 does not say that he has any prior criminal history or failure to appear, and that that's not related to this person. So on these facts, I'm hopeful that I can release him on his own recognizance with that court date. Now, if when I see him, it does not appear that that is a good idea or that he will comply with release conditions to come to court, I'm going to advise him that his court date will become March 12th at 1 in the afternoon, and I'm going to give him a $500 secured appearance bond. So my final order will reflect the court's ultimate decision. In that case, I do not intend to update this recording. My final order will contain the court's ultimate decision after I see Mr. Matamura Frazier. But it is currently my intent to release him on his own recognizance. Sarah Michaela Valdez, born 3/23/77, got booked in for dangerous drug possession, class 4 felony, aggravated assault on a correctional employee, class 5 felony, drug trafficking possession, class 6 felony, and resisting arrest, a class 6 felony. There is probable cause for all of those. I am appointing a lawyer for her. The next court date will be a status conference March 10th at 8:30 in the morning with the preliminary hearing March 13th at 8:30 in the Downtown Superior Court, and the court is currently inclined to set bail in her case in the amount of $2,500 secured with written conditions I will go over with her, including no initiation of contact with any alleged victim, and I will advise her that means to the extent that the victim officer is still working here at the jail, she cannot initiate contact with that person. No weapons, no drugs without a valid prescription. If anything changes after I see her in court, then my final order will reflect my ultimate decision, and I do not plan to update this recording. All right, with that, we are going to stand in recess until the 2 p.m. calendar.